All right, I'm going to convene the North Dakota Ethics Commission here on, what is it, Thursday, January 22nd, 2026 for a special meeting. An agenda has been sent out, and we will stick to the topics on the agenda since this is a special meeting. And we'll note that Commissioner Goodman is still going to be joining us. Otherwise, Commissioner Sharp, Commissioner Western, and myself are online, and Commissioner Hubert is in person with our staff in the Bismarck office. Good morning, everyone. Hopefully you're all warm and well and safe. It's good to see you all. Happy New Year. And our first order of discussion is the proposed complaint rule amendments. And I'm not sure, Rebecca or Logan, who's going to take the lead for us.
I believe Logan is going to take the lead, Cindy, and walk through the proposed amendments. In the memo that was provided to the commissioners, what we did is we did just kind of a brief overview of what the changes were. This is in a very summary fashion, just as an overview. But what the commission asked for is for us to walk through section by section and talk about what the changes are and why there are changes. But I think it would be good as we go through each section to get feedback. Right, Cindy? Is that what you're thinking? To get feedback on each section? Okay.
Yes. Yes.
So with that,
May I ask a question also, Rebecca and Logan? What so our staff has responded to the comments we have received from the various bodies or constituents relative to these rules. Does that just come to us, the commission? And is that an internal document that we use to get to this version of the amended rule? And I'm asking because I'm curious, does the public see those documents?
It depends, Cindy. They can request them. They're open records. But
Okay.
what happens to them is they're part of the rulemaking record.
Okay.
So once the commission approves the final version, all that information will go to legislative council. And then they'll publish the code and they keep that all on file within their office. So people can request it from them as well once we're done rulemaking.
Okay. Do we, so it's all public then, but we don't formally issue a response to whoever provided those comments?
No,
Okay.
you have to consider them. You don't have to respond to them. There's that slight distinction that you consider the comments. You can send out a response if you want to, but you're not required to.
Okay. Okay. I was just curious, and I thought that was the practice, but I thought I better clarify. Thank you.
all right, Addie, if you want to bring up
Attachment 8. I'm having Addie bring up the marked up version so we can walk through it.
Can you remind me what attachment was that?
That would be attachment 8.
Oh yeah, got it.
Okay. So you'll see on this document, the green is what was added when the commission initially proposed the rule. And whatever's highlighted is what the commission changed / added at its November meeting. That's why you see the last updated date at the top is November 29th of last year. So walking through the definitions, alleged violation is now defined because the commission before it does the final report and the hearing has to consider whether or not to issue an alleged violation, require additional investigation, or close a complaint at that stage. So we needed a definition of alleged violation. Okay. So moving on to anonymous complaint. I think that is defined because it's I think we noticed somewhere else in the rule that it uses the term anonymous complaint. And it's not defined, so we added a definition, and that's why you see anonymous complaint there. There's certain things as we go through each rulemaking process that we'll catch things that need to be cleaned up or added, including number 3. Oh, there we go. Anonymous
We need
complaint.
to redefine it.
It was out of order. It was not in alphabetical order. So it's moved up. That's what that one is. But when I talk about cleanup, that's what 3 is, where you see the director, officer, commissioner, head. The complaint process didn't take into consideration the commission's quasi judicial jurisdiction. So there was no process really to process those complaints or those issues. So that language is added. So the complaint process now works to process those allegations against those individuals, where the commission has specific jurisdiction that's a bit broader than its general jurisdiction over lobbyists, public officials, against those other individuals.
And that jurisdiction originates in the Constitution,
Yes.
correct?
Scrolling down, you see,
Can I just want to clarify something? Can you go back up to 1 under alleged complaint or alleged violation, excuse me? In that definition, we included, this was, I believe that we talked about this very early after last legislative session. You'll notice that the alleged violation is issued by a majority vote of the commission. So that requires 3 commissioners, correct? That's not just where we have a quorum of 3 with 2 voting. So I just wanted to clarify that. That is a little bit of a higher standard for that alleged violation definition.
if anybody else has questions too, please
Yeah.
feel free to interrupt me. Moving on down to subsection 6, ethical violation is now defined because it's used later as a term of art in the rules. And then responding, that has so the Century Code didn't use the term respondent, the commission's rules always did. But now instead of cross-referencing, it's more accurately defined. The language is all there. Plus we add director, officer, commissioner, head to include the quasi-judicial jurisdiction. Moving along to the next section.
Can we maybe make sure, are we good on section 1? Are there any changes, questions specifically on section 1?
Not hearing any.
Okay. Next section, jurisdiction and limitation period. So again, here, the political committee contributor, that language is added because the Century Code includes that language. I think that was missed during the multiple iterations of rulemaking on the complaint rules. So that group and that specific individual, those types of individuals are added. And then there's that added sentence about the commission's jurisdiction over quasi-judicial proceedings. And then,
All right, I want to jump in on this one, if I may, please, Madam Chair, and may it please y'all, in asking questions about the jurisdictional section of the proposed changed rule, I looked at the Attorney General's business from September, and they weren't particularly friendly, though the Attorney General's office often may not necessarily be friendly to the commission, but that's a conversation for another day. I guess my question is, at this point, were there amendments made to the proposed rule after the comments from the Attorney General's office memo dated September 9th, or is it the same thing?
There were some changes made since that memo was submitted to our office as a comment. Some were
Okay.
in response to that. I'd have to go back and look at exactly which ones were in response to that, but some changes were made based on the comments we received.
Well, and the biggest concern that I've got is the idea that somehow by rulemaking, we are increasing our jurisdiction. I don't see it in the proposed rule, and maybe different people look at proposed rules in different ways, but that's the issue that I'm kind of trying to wrestle with the most, just as far as this particular section is concerned. And I also understand that both the original rule and the amendment process all predated my existence, and some of this I may just not be up to speed. And so to the extent that I may be repeating things, I apologize, but any help you can provide is appreciated.
Sure, we can do that, and as I walk through these, I'll remember which changes were made specifically in response to their comments. So I'll flag those once I remember. I can bring it up. Do you want to add something?
Yeah, Commissioner Western, so in section, I'm gonna just call it the jurisdiction section. Is that okay if I do that?
Yeah, sure works for me. Sub 2
Yeah.
or whatever it is. Yeah.
So when we originally looked at how the rules should be drafted, one of what I thought was an oddity, and this is just based on what we typically see in rulemaking, is typically an agency doesn't say what they don't have authority to do.
Mhm.
Typically, they outline exactly what they do have authority to do. And the fact that other things are omitted ensures that you are not doing those things, or that you are not articulating it. Because if we were to write a statute and then include all of the things that statute doesn't do,
Right.
that could be difficult, and that can affect the interpretation. So when we look at sections that are numbered in this particular updated, that was last updated in November, sections 2 and 3, which are entirely blocked out. These are sections where the commission says what we don't have authority to do, but there are lots of other things that we don't have authority to do. And so I looked at this, and I look at this as surplusage entirely. And so that is why we removed it.
And I'll
If
admit, I
we're-
think that 2 and 3 are taking those out are harmless. I don't see anything innocuous or untoward about it at all. I think that all makes sense. I don't want to have us all put words into the Attorney General's office's mouth, but was their position that by cutting out 2 and 3, that somehow increases jurisdiction?
So the impression from the comment that we received is that by taking these out, the commission, in effect, concluding that they may have jurisdiction over those areas. And that's not how we interpret it, how a body would interpret the commission's rules. And I would add on top of it that if we look to the FAQs on our website, which are not official rules, we do then in that section articulate frequent things that come to our office that we don't have jurisdiction over. And that would include personnel matters and matters of local issues, or employees of the executive branch, et cetera. So we do this in other places. I just don't think it's appropriate in a rule, because otherwise then we'd have to include all of the other things we don't have jurisdiction over, which would be exhaustive. I mean, it would be lengthy.
then I have no issue with anything else in the jurisdiction section. And I appreciate the clarification. I think that all makes sense and it's all done in good faith.
All right,
I would just,
let me just apologize for being late to the meeting. I got mixed up with this meeting and next week's meeting, and I apologize.
Welcome aboard, Ron.
Thank you. Thank you, Addie, for calling me.
I'll finish the section sub 3 there. Sub 3 there was to clarify the commission's jurisdiction when it receives a complaint, that its jurisdiction will continue until the process is over, essentially. But I will add, I see a typo. It says final action on a compliant. That should be complaint. And should the commission approve it, we'll make sure that typo is fixed.
I was just gonna add, this is Jared, I was just gonna add to Mark's comment, or question, I guess, in subpart 2, I think we're clarifying, it's not our intent to expand authority, but rather to look to Article 14 as the authority for what we do have jurisdiction over. I appreciated that annotation, Logan. And then for subpart 3, it just seems to me like we're removing duplicative language, really. That's my general observation, and I feel like removing those two parts I'm okay with that.
If there's no further questions, I'll move on to submission of a complaint. Just cleaning up some odd language. A complaint will be denied. We change that to summarily dismissed, just because that's what the process is. It's not denied. The commission summarily dismisses complaints. Relevant information was taken out, submission of a complaint. That's what we received through this process. So that's why it is broken down to complaint. And then this is one where we changed it in line with one of the comments we received. I think it was from the Attorney General's office. To ensure the commission has necessary information to process a complaint, we may direct them to use the designated complaint form. Somebody can submit a complaint to our office in any format they wish, but sometimes they don't include all the information we need. So we'll either reach out to them and ask for that specific information, or if it's easier to them, a standard practice is we just ask them to fill out the designated complaint form, because that prompts them for everything that we need anyway. So it's just formalizing that standard practice that if they send us something that's hard to read, sometimes penmanship's hard to read too, that we'll ask them to use our form if possible. But if they don't, then we proceed with the original submission to the best of our ability.
Madam Chair, just 2 points of clarification, if I may. I guess, Logan, the relevant information was struck in favor of complaint because it wasn't defined, right? Relevant
Correct.
information wasn't defined. And then the highlighted portion there regarding what format a complaint can be submitted in. The previous version of the language kind of read like we said they could submit a complaint in any format, but then we also asked them to submit it on our form. And this is just sort of clarifying that we really will accept any form, but it's easier for us, it's more convenient for us if they use our designated.
Correct. Yeah, we may go back to them and ask them. They can always call the hotline. They can do whatever they want to. They can send a letter to our office. But if we get it and we can't read it, it's hard to process it. So we may just direct them, please use our designated form. Otherwise, we have to go off of what we can read with what's submitted.
To summarize, they can submit it in any format, but if we can't read it, we have to do something about that.
Yes.
Thank you.
Thanks for the question.
For the public's information, can we talk about in number 3, the use of the word relevant information? Why that was initially included? And we're taking it out because there is no reference in either the statute or the rest of the rule. But where does that term come from?
I'm not, I don't know if I can answer that because I wasn't there when the commission first adopted it. I think it comes from Article 14, which uses the term that you may submit relevant information to the commission. But later down, just the term information is used, so it's inconsistent within the complaint rules itself. That plus it being undefined makes it confusing what we're actually getting at. So if we just go back to complaint, which is defined, it makes it easier to follow, given it's the complaint process defined term.
And it stays consistent then too, right?
It's consistent.
Because otherwise, right now, if we were to leave that relevant information in there,
We'd have to assign a
We-
plain language meaning
we
to
would.
it, which
and then people could submit something that's not considered a complaint, but relevant
We don't.
information.
a way to move it forward if
Yeah.
it's not a defined, if it doesn't meet the defined criteria for a complaint.
Okay.
So that's the thought process of why it's removed. I mean, we could go back and define it, but it's not a necessary term within this process because complaints defined. Move down to sub 7. You'll see executive directors struck throughout this section in favor of commission. That's putting the authority back with the commission, that it's on the commission to initially review a complaint. And that the commission is the entity that will summarily dismiss a complaint. This is in line with standard practice. The commission currently directs the executive director to summarily dismiss complaints. But by bringing it back to the commission, it's with the 5 commissioners who are appointed are accountable. You're making the decision rather than staff. So the rule now reflects that. And then it also gets rid of this convoluted process. You'll see there is all struck where somebody can appeal the decision to summarily dismiss a complaint to the commission. What they do in practice essentially is ask the commission to reconsider its decision. They can always refile a complaint if it's within the 3-year period, but it's an odd process to appeal a decision to the commission that actually made the decision in the first place. So by putting it back with the commission, removing the executive director as the decision maker, there's no need for the appeal process. So that's also struck. Hope that makes sense. And then that highlighted commission and the new C, that was one that was missed. Oh, actually, I think, no, this
That
one
in
was,
response.
this was in response to a comment that the commission refers the complainant to the relevant agency, which they can do through the executive director with direction. But again, you'll consider that at a meeting and say, should we refer them to X, Y, or Z agency with their complaint? And the commission now officially does that.
And this is really just to ensure that the executive director is not doing that on his or her own,
Sure.
which we don't want necessarily, unless the commission wants to do that, but I would prefer not.
And again, that's in line with the standard practice. The commission already does that. And when the letter goes out from the executive director, that includes the information that the commission considered at the meeting, including whether we're referring somebody to somewhere else. Then sub D there, the new sub D, that is the criminal referral process. This is due to the statutory change. So you see a shall is struck in favor of may. The referral process used to be mandatory under the statute. The legislature changed that to a discretionary process to may. So the commission does not have to refer everything it has a belief that criminal conduct, they can direct the complainant to go take their complaint directly to law enforcement rather than being a clearinghouse for all those matters, a mandatory clearinghouse for all those matters by statute. Added language just to clarify that we don't take further action until the criminal referral is resolved. The biggest one there you'll see is if the law enforcement agency takes no action on the referral for prosecution within 60 days, the commission may resume its review. So under the prior process, the commission had to wait until it was all the way completed. Sometimes we would refer things and it would sit on the prosecutor, whoever's reviewing it, it would sit on their desk and we wouldn't be able to get any information about it. So we just have this complaint that was stuck in perpetuity until they were done with it. And we couldn't dismiss it. It was just sitting there as pending. We didn't have any information. We couldn't process it forward or close it. This allows us to do that if there's no action from the law enforcement agency. And then there's just clarifying language about unless the agency accepting the referral objects, we have to inform the complainant and respondent of the referral.
Can I talk about that language change right there? So, I have the, I'm typically the one who's going to be referring or who communicates with law enforcement on these. And when both myself and law enforcement agencies looked at this language where it says absent rejection by the referring entity, many times we had a question about whose duty it was to object. Did I send it out unless they object? And there were many times where we had conversations about, are you rejecting it? The language was very odd. And in reality, having the clarifying language, unless the agency accepting the referral objects, is much clearer so that I can ask them very directly. Do you object to us notifying the respondent or the complainant about this referral? That seemed to be the language that we use in practice versus this rejection. And it is in statute.
It mirrors the statutory language.
But that statutory change was from 1360.
And then you'll see number 8 there is struck. That's because the commission's the one summarily dismissing or referring complaints. So you shouldn't need a report from the executive director because the commission's the one taking action. You're there for it. You should know about it. And then the appeals, that won't be a thing anymore. So it's unnecessary language. So we struck it. Any questions on that whole section?
This is Ron. I take it then at each meeting, we'll see each complaint that comes into the office.
You already do, Ron, so nothing will
Yes.
change in practice. There'll just be some terminology change, like when you do the motion to direct the executive director, that'll change to motion to summarily dismiss complaint number whatever.
Okay,
Won't be directing Rebecca to do it because the commission will be doing it itself. If there's no other questions, I'll move on to notice to respondents and motion to dismiss. You'll see, again, information is struck where it appears throughout the whole complaint rules where it's not a defined term. Accused individual, that did appear in our rules, even though it wasn't used as a definition. Somehow it creeped into other pieces of the rules. So just changing that out in favor of respondent. And then number 5 there, new number 5. This is in response to the statutory change that allows a respondent to file a motion to dismiss. And then those are the grounds they can assert their motion to dismiss on, which is in line with what we review in an initial review. There's no questions on that section. Okay. Informal resolution or settlement with the commission. Number one there, without further investigation, that language was kind of surplusage because it doesn't necessarily need further investigation to be resolved. But also now with the new statutory change that is in 6, the commission can settle complaints after the informal resolution process where the complainant, I guess I should explain that process. Informal resolution happens after the first stage, which is the initial review. Then we move into informal resolution. The commission sends out form letters we have asking the complainant and the respondent both to opine on whether they would be interested in essentially mediating a resolution of the complaint. If one of them or both say no, then it moves on. But if they both agree to this process, then the commission essentially acts as a mediator through its staff to try and resolve a complaint without moving it forward. That has historically not been very successful. In line with that, and the commission telling the legislature that, they amended or added a piece where the commission can now, after an unsuccessful informal resolution process, the commission can step in, work with the respondent directly to try and settle a complaint. The commission has already adopted settlement guidelines in line with that, so now we're changing the rules to formalize that process. So you'll see there, if informal resolution is unsuccessful in 6, the commission may work with the respondent to settle and close the complaint matter at any time pursuant to the settlement guidelines the commission has already adopted. Or if that's not successful or the commission thinks an investigation is warranted, you may investigate, as the next section lays out. Any questions on that?
Logan, could you move the page up a little bit? I can't see the last couple page, the last couple lines in there. Yeah, there you go.
Okay. No more questions. Complaint investigation. The first line there is in line with what we just talked about, changing it to be informally resolved or the new settled with the commission. Again, relevant information. Here, information means something where we're requesting information from people during the investigation. Relevant information, again, it's a term that's used in the Constitution, not defined. So we're not completely sure why it's relevant information here when we are just asking for information. I mean, it could be relevant, it could be not, depending on what they give us, but it's a request for information. And that's all the changes in that section. Okay. Moving on to reports to the commission and the complaint record. This was, you'll see investigation report is crossed out. That's accounted for later, and the legislature added that extra step before there's a report. The final report is made. We have this interim step where it goes before the commission. Well, prior to that, to issue an alleged violation. So that's what this section, all the green, takes care of there, where we designate it as the preliminary report and recommendation to the commission. And that will request the commission close it or issue an alleged violation. And for the attorneys in the room and online, that was, I guess the parallel we draw there is it's like a request for or review for probable cause, essentially. Should this move forward, is there something to it that it should move forward in the process? And it doesn't require a long report necessarily. It can include some of the facts to move it to the final hearing essentially without getting into all the details right away. So it saves staff time because we don't have to write as detailed reports if we're going to close something. It also involves the commission more as we move along in the process. So we designated that as the preliminary report. And then the commission has 3 options there. You'll see in subsection 1, the commission may issue that alleged violation. You might think there's additional steps that need to be taken, so you can require additional investigation as well, or you can close it at that stage. And then if you issue the alleged violation, that's the direction to the executive director to prepare that final report and recommendation with all the investigation findings and the recommendation for how it should be handled to resolve the complaint. And then it just says that it should include the executive director's recommendation. And then 3, this is where we get into the record of the complaint, what's provided to the respondent. That's the commission's investigation file. So it's everything that we have essentially on the complaint that we include and save as we go along in the process. And that's the investigation file documents, interviews, recordings. And then that's obtained during the investigation, just designating that as the record for what will become the final hearing. It's the record for the complaint. It's all the findings, essentially. I don't know what more I can add there.
everything,
It's
yeah.
it's everything we have. It's the discovery essentially from the commission's complaint investigation. Any questions on that section? Okay, commission review and action on complaint. You'll see here there's some yellow that was changed in November. This was in response to a comment about a timing concern, which upon further review, it wasn't exactly clear on when the timing of things would occur. So the way it works, you'll see the final report and recommendation and the record is provided at least 10 days prior to the meeting at which the commission will conduct a hearing on the complaint in executive session. The final report, then it gives the respondent an opportunity to respond to the final report and recommendation no later than 5 days prior to the meeting where the hearing is conducted. You may think that's not very much time. I'm not exactly sure how it was originally set up at 10 days and 5 days. In practice, they can request more time and we give them more time. We work with the respondent to figure out how much time they need before we even set the meeting, essentially in conjunction with the chair. But there needs to be a deadline in the rule. So it was priorly agreed to that it would be 10 days and 5 days.
So in practice, we at least verbally offer them more time if they feel 5 days isn't enough.
It's usually at least a month. Yeah, we have a
We have a stipulation.
stipulation form that we
have.
give them. But now if you have somebody who doesn't want to agree to a certain time frame, then we have to fall back on the deadline. Well, you have 10 days now because you're being difficult for whatever reason. So there is a deadline. It's not used. Well, I guess I shouldn't say it's not used very much because we went through the process once, but we didn't use the 10 days because we had a respondent that was willing to work with us and set a time that worked for everybody for the final hearing. But there is the 10 days if we need it. And then if they respond, that is forwarded to the commission through our office by the executive director. And that becomes part of the record, their response to the complaint. Number 2, again, just clarifying the time there that the commission will take action. That's struck in favor of conduct a hearing because you may adjourn and take action at a later meeting. So the response is provided during the hearing, so that's clarified. And then at the special or regular meeting, to clarify, on commission meeting was somewhat vague, but we use the term special or regular meeting, so just using that same terminology, which you see carried through there into sub 3. And then this formalizes the commission's process at that meeting, where we do it in hearing format, with the chair or the chair's designee acting as the hearing officer. Presentations by both the executive director and the respondent. The hearing officer then is the designee to determine all procedural matters. And then added a line that the hearing officer, if there's testimony, they may administer an oath or affirmation to the witness to provide the testimony. Moving into sub 4, making sure there's a recording of that meeting. If it's by Teams, we'll usually do a video recording like we do with all our meetings. If it's in person, there may just be an audio recording. And then the second line is making sure that we can do it by Teams. It may take place via reliable electronic means, which is the term the court uses, but it essentially means Zoom or Teams, whichever works the best. And then clarifying in sub 5 that provide an in-person response to the final report and recommendation. Sub 6, that's where the commission deliberates on the complaint, and we wanted to clarify there that it's outside the presence of the executive director, commission staff assisting the executive director with the investigation, the respondent, and the respondent's attorney, to make sure that there's no ex parte communications as the commission deliberates. That's the commission's decision. You should be able to meet in private and make that determination without essentially the parties watching you, the parties to the hearing. And then you determine that highlighted portion. Ethical violation is defined, so we shorten that to ethical violation in response to a comment that pointed out that the definition was used and not the defined term. And then 7, following the commission's deliberation, the commission issues an order with its decision that becomes the document that officially records the commission's decision, whether there was an ethical violation or not, and that the respondent is provided a copy. Any questions on this bigger section on the hearing? Appeals to district court, there's nothing changed there. They can appeal their finding to district court within 30 days. Rules of evidence and procedure, that is just changed from case to complaint to keep it consistent. Computing time, nothing changed there. That was adopted based on the court's practice of computing time and added. So we had a set time frame. Management time standards. This is new in response to a statutory change that requires the commission to adopt complaint management time standards for the complaint process. You'll see that there's yellow in 2, 3, and 4. That was the original proposal was changed at the November meeting to what you see in front of you for the time management of complaints. The original version was borrowed from the court. This version was made after discussions of what works for the commission's process and simplifying that whole process. So you have up there some language that deviation from the standards, it doesn't cause the dismissal of complaint, but the commission should be reviewing it promptly if it's open excess of the guidelines. So you'll see there, the commission, if it determines it doesn't have jurisdiction, you have 60 days to dismiss it, summarily dismiss it, essentially. Sub 3, anything that's open for more than 180 days, the executive director shall be providing a report at meetings in March, June, September, and December. And sub 4, any complaint that's pending for more than 365 a year is on the agenda for every commission meeting, every regular commission meeting, should clarify. So that's the time management standards. The statute directs that the commission should adopt them or shall adopt them, but it left it up entirely to your discretion what these time standards include. So that's what we've come up with today.
So if we don't summarily dismiss something that we don't have jurisdiction over, complaint that we don't have jurisdiction over within 60 calendar days, it just goes to the next meeting, essentially.
Essentially, yes. Yeah, what we need to properly review it.
Sure.
The hope is that we were promptly, if the commission determines it doesn't have jurisdiction, you're usually acting on it during that same meeting. So there may be some instances where you ask for more information before a complaint's dismissed, so that leaves it open to put it on 2 subsequent agendas. Any other questions on that one? Okay, then the last,
1 second. Jared, just to get, you had asked about if we don't dismiss it within the 60 days. Just to provide the public and the commissioners information, in the annual report, the commission stated that as of June 30th of 2025, on average, the commission summarily dismisses complaints over which it lacks jurisdiction in 29 days. So that even gives us a 31-day window to be working with.
Thank you.
okay, the last section. Complaints submitted in bad faith. This was added at the November meeting after a proposal by then Commissioner Sogsmean. And this, the reason behind it was, I guess I should speak for him. My observation of the reason behind it was that the commission, there has been concerns communicated to the commission that people use the process to submit frivolous complaints to harass or impugn the reputation. Mostly most of those comments come from public officials that people are using it to harass or impugn their reputation. So there's been an ongoing discussion of what the commission should do in those circumstances. And this was the proposal from Commissioner Sogsby, that if somebody's doing that, that the commission should propose in its rule that it can impose a sanction against those individuals if they're using the process to do exactly that, to harass or impugn individuals. So you'll see there that they get notice, and then the commission may issue an order to show cause. They get a reasonable opportunity to respond to the order to show cause, and then the commission may impose an appropriate sanction on the complainant pursuant to those rules, which may include the monetary sanction you see there, up to $500 and up to $1,000, but it also may include non-monetary directives. This section, it does invoke the discussion of whether the commission can penalize somebody who's filing a complaint. That, if you want me to go into more detail on that, I can certainly do that. But it has been a discussion of how the commission should respond appropriately to people who are using their process for means that aren't on the up and up. They're not using it to, in good faith, complain about an potential ethics violation that they see. Okay.
Am I
No.
correct to assume that this, and we're not 100%, everyone is not in agreement that we have the authority to impose a sanction? This would sort of open the door for other sanctions. Is that a correct assumption?
It depends, Pam, and I know that's not a great answer, but I am working on a memo regarding the commission's ability to impose penalties as it relates to people that are under the commission's rulemaking authority. So that's the lobbyists, the candidates for office, the public officials. Notably absent from that group of individuals is complainants. So I have concerns with this section that you're creating a rule, if you approve it, that you're creating a rule over an individual that's not outlined in the Constitution that you have rulemaking authority over. That person being the complainant, where you're going to now issue a penalty pursuant to something that's outlined in statute that doesn't take this into account. In my opinion, as the commission's counsel, the legislature created the complaint process. If they see it, complainants, they use the term weaponizing it as a problem. Maybe they should take care of it and fix that situation because they're the ones that created this in the first place. Now, as it relates to penalties for other officials, like the travel rules, I think that's a different discussion, which I will go into more detail once I get that memo out to you, which I'm finalizing.
I'm going to add something, Pam, to that, and not for the purpose of taking a position, but providing information to the commission. The commission may well, and I use may, right? Because there is no case law on this. There is no North Dakota Supreme Court decision that the commission has inherent, to some extent, inherent authority over its processes. And so that would be the authority to impose a sanction. That is where effectively that authority would have to come from in this instance. That is distinct from any penalty included in a rulemaking authority granted to the commission through its constitutional authority. That is the difference or the distinction, if that helps with the distinction potentially between the two. However, I'm just providing that for informational purposes, not to provide an opinion one way or the other.
Madam Chair, I have a few questions.
Yes, go ahead.
A couple of them relate to what Logan and Rebecca were just discussing. But I'm hoping for maybe just a little more clarification. But first, as it pertains to a complaint submitted in bad faith, I guess I'm of the opinion that I think we need the bad faith to tie back to transparency, elections, corruption, and lobbying. Otherwise, I guess I'm in agreement with Logan that I don't know if the complainant is really under our authority to levy a fine or a sanction against. If they're violating ethical rules to influence an election, for example, then maybe I just, to me, bad faith is maybe a little subjective. I guess I'm just throwing that out there as a comment if anyone has additional thoughts. And then part 2 of this section, Logan, I was hoping maybe you could explain to me the show cause portion of that. So to me, we may order the complainant to show cause why the complainant has not violated subsection 2 of section 3. Are we asking them to sort of prove a negative? Is that kind of an exhaustive thing that we might be asking someone to do?
Sure, so it's essentially asking them, we think you filed this in bad faith. Explain why that's not the case. That you did file, yes, prove it, prove that it was filed in good faith, essentially.
Sure, okay. And if I could
And if-
play devil's advocate. Sorry, go ahead.
I want to jump in only because I think this is the most lawyerly part of the section. This is kind of parallel to a finding of contempt of court. When a person doesn't obey or allegedly doesn't obey a court's order, and there's a motion for contempt, or when a person doesn't provide discovery and it's in disobedience of a court's order, then there often is what's called a show cause hearing. And the show cause language is almost identical here. Please explain why you shouldn't be held in contempt. Please explain why this shouldn't happen. That I don't know that that's a normal thing outside the legal world, but I suspect that that is exactly where the show cause language comes from, the same as the language of bad faith versus good faith. It certainly is an abstract and subjective thing, much like finding whether or not something's obscene. I know it when I see it. It's inherently a catch-all, or at least I presume that is why and how it was drafted as it was. Pardon the interruption.
That is correct, Commissioner.
Thank you, Mark. That's what the explanation I was hoping for. And then lastly, as it comes to imposing a monetary sanction, again, I would go back to say that I agree with Logan about imposing a sanction on a complainant as it pertains to other public officials who we may have jurisdiction over. I think we could. I don't know if we should in many. I can't think. I'm sure there's examples out there where maybe we should, but I can't think of one right now. And if we were to say that we can't impose a sanction, is that saying something else about our authority to enforce the rest of Article 14? I mean, are we making a broader statement if we were to not to say we cannot impose sanctions? Are we making a broader statement about our authority under the article?
To me, no. In my mind, I separate them as two issues.
Okay.
So when we talk about public officials, candidates for office, and lobbyists, Commission's rulemaking authority for that flows directly from Article 14. Complainants aren't included in that, so then we have to, working back from this, where does this come from? Well, a complainant, again, not defined in the Constitution, is created through the legislative process that they set up in 2019 for complaints. So working back there, they created this whole complaint process that the commission has to implement. So we're doing that pursuant to statutory authority. Essentially, we're creating the rulemaking. Some of this does invoke the Constitution as it relates to the people we have jurisdiction over in the Constitution. But complainants, that's a new individual that's introduced to the process through the legislature, through the complaint process. And now the argument becomes, we need to be able to control the process. So that's where this proposal, in my mind, comes from. The argument is the commission needs to be able to control the process it oversees. So that arguably includes the ability to sanction individuals who are misusing it, which isn't from Article 14. It's more of an inherent authority argument that we do this, as Rebecca said, we do this process, so we have to control it and make sure it's followed and do it to the best of our abilities. And how can we do that if we can't deter bad faith complaints? That's the argument that's put forth. Whether a court agrees with it or not, like it's an open legal question.
Yeah.
But you don't have the Article 14 basis in this circumstance, in my opinion, to back up the sanction as you would in other certain circumstances.
I will just conclude my questions on this section by saying I am not comfortable with the language about imposing a sanction on a complainant. I think it is simpler for the commission to summarily dismiss that complaint and perhaps communicate with the appropriate, agency who the complainant might fall under, if appropriate, that there may have been some bad faith, but I'm not comfortable with the levying of monetary sanction on a complaint.
Madam Chair and members, I agree with the commissioner in part. I don't know in terms of connect the dots that I think that the Ethics Commission has the legal authority to impose a monetary sanction, but what I do think is that summary dismissal is its own sanction. Now, I think that there's maybe two different hypotheticals that are coming up that I think that we're maybe considering. One hypothetical is John Smith submits a complaint against legislator X over and over and over and over for maybe the same or similar alleged violations. It's almost akin to the vexatious litigant in the world of courts. And I think that I know that courts, once a person invokes the jurisdiction of a court by making a complaint, then invite the ability to be sanctioned by the court. And I suspect that that's where counsel will go in terms of inherent authority. I don't know that the legislature has provided us with the actual inherent authority to provide a monetary sanction. And I don't know, I have concerns that that may create a disincentive for a person to make a complaint. But here's what I do think. If you back up respectfully to the language that discusses what a commission is going to do, even when they find an ethical violation, which is on page 7, it's 115-02-01-08 sub 6, where it says something like, the commission shall determine what penalty, comma, if any, comma, authorized under North Dakota law will be imposed upon, in this instance, the respondent. In lieu of a penalty authorized under North Dakota law, the commission may refer the matter to another agency with enforcement authority over the violation. I don't know that the last sentence is necessary, but I would be far more comfortable with language that is almost the same. The commission shall determine what penalty, if any, comma, authorized under North Dakota law will be imposed upon the complainant, including, comma, but not limited to summary dismissal of complaints from that complaint. I think that could maybe fix and during the legislative session of 27, members of the commission, et cetera, can have conversations with the legislature about exactly what authority we want to expressly have from the legislature to be able to impose a penalty so that it's in black and white in the statute. I think that may fix this. The other hypothetical that I think about that I don't know that I have a solution to is that we are required by, I believe, the Constitution to have a confidential whistleblower hotline. And so it is expected, if not possible, that complaints can be submitted anonymously. If Anonymous makes a complaint in bad faith, frankly, I don't know what to do about that because I don't know how to have any type of authority over Anonymous. And in that instance, maybe there's not a solution, but those are the issues that I personally see with respect to the penalty section. I don't know that we can do anything about an anonymous complaint that's made in bad faith, but I suspect that there are bad faith complaints that are out there. And I think that the commission has the authority to determine a penalty as authorized by North Dakota law. And I especially think that the commission has the authority to impose the sanction of, we're summarily dismissing anything and everything from you, vexatious bad faith, Mr. John Smith. But those are thoughts I could move to amend, but I'd be interested in other people's thoughts regarding the same. I yield.
This is Ron. I'm concerned about the person who, and I don't know if we've had this yet, but I'm concerned about the person who makes a complaint and then publicizes that complaint outside of the commission. It can happen in elections, especially where candidate A says that candidate B has had a complaint filed against her in with the Ethics Commission, and that is a concern. And I don't feel that we can not have some kind of a sanction in that particular instance. You know, maybe we look at less than $500 for the first offense and less than $1,000 for the second offense. But you know, that can be very vexatious, and it can compromise an election in a very negative way. So that's my opinion or my comment. And there may be other situations that occur too, but the election one is something I think that we have to be concerned with.
So Ron, my initial comment on, and I agree that would be a concerning scenario. My initial comment was maybe we need to tie some of this language back to transparency, corruption, elections, and lobbying. And if a bad faith complaint can be tied back to those areas, then we could potentially consider a sanction on that complainant. I'm still not convinced we have jurisdiction over them, though.
So
Go ahead.
I'm wondering if Logan and I are thinking the same thing. So Ron, to combine your thought and Jared's thought in a subsequent rule, an independent rule separate from the complaint rules. If the commission were to have a rule that if something was, and please forgive the off the cuff language, but you will get the intent of this, is that if a complaint is filed for the purpose of influencing an election that ties it to an election corruption, transparency, but it's an independent rule, so it would be an ethical violation by the person who is submitting a complaint for that purpose. Now, the jurisdiction would be limited to candidates. You know, it wouldn't be broad in the sense that we could still get some of those from individuals. But if, let's say you're in a candidate situation where it's one candidate files a complaint against another candidate, it would at least alleviate that particular concern. So that may be an option that the commission could look at, tying it into, if it's done for the purpose of influencing an election. Now, proving that you'll always have a proof problem because you have an intent element there, but we could articulate what specific characteristics.
You'd work through the complaint process.
Yes.
You could get a complaint that candidate X filed it for the purpose of influencing the election. So then we walk through this and do an investigation, essentially.
Yeah.
That's not
And
what I
that-
was gonna say.
That's not what you were gonna say. Okay.
So
I mean, that might be one way to combine what Ron is concerned about with your concern and come up with a solution. It's not a now solution, but it's something that the commission could certainly do in the future or draft a rule to that effect.
yeah, I heard Ron has a comment too, but if the person submitting a complaint in bad faith is a person that we have jurisdiction over, we may investigate. If the person submitting a complaint in bad faith is a person that we do not have jurisdiction over, could we summarily dismiss based on the submission of a bad faith complaint?
So that gets to what
Yeah.
I was gonna say. Addie, can you go back up to page 3?
So
So-
considering Commissioner Western's
Yes,
comment,
drafting suggestion in consideration of both of your comments. Scroll down just a little bit, Addie. We go back to what is this section is submission of a complaint where it articulates the grounds that you may summarily dismiss a complaint on. You could add a sub 4 here and say, or was filed in bad faith. If the complaint was filed in bad faith, that's a ground to summarily dismiss it. And then the second suggestion would then be to parallel that when they can file their motion to dismiss, which is on bottom of page 4 there. Scroll down a little more, Andy.
one right there.
Adding a E there was filed in bad faith.
I want to point out in that instance, making that drafting change, it is discretionary language. It is a may, not a shall. So that, let's say we do receive a complaint in bad faith, but there is something or there is substance to the complaint where the commission may not want to dismiss the complaint because it is an issue or it is a potential ethical violation. There is a may language there, not a shall.
Yes, that also takes it out of the context of the complainant's actions. You're not acting on the complainant themselves, but you're acting on the substance of the complaint, the intention behind the complaint, but the document or what's submitted to our office as the complaint and not the complainant as a person.
Is
Concur.
there any reason, and are we getting out beyond our skis? And maybe this also could alleviate things, including in the jurisdictional proposed rule in sub 3 that the commission shall have jurisdiction over a complainant and respondent, or a named complainant. I don't know if you can have jurisdiction over anonymous, or whether that distinction is important to note, but I don't think it's outrageous that if a individual files a complaint, it creates jurisdiction. I don't know that that makes waves, but maybe we're getting out beyond our skis.
Actually, Mark, I think that's a question I asked. Maybe not quite in those words, but didn't I do that, Logan or Rebecca? So once somebody files a complaint and they become a complainant, I couldn't understand how come we don't have jurisdiction over that person.
Yes.
And it's not so much jurisdiction as it's okay. So this individual is filing a complaint, and then we just outlined the steps of how we're looking at that complaint. And so then if we find, well, whoa, wait a minute, this person is, and again, yeah, it is very subjective. We're thinking that in the scenario that Commissioner Goodman outlined about candidates for office, elected office during that election cycle and that. Yeah, anyway, I've been very confused, but I'm like, oh, wait, no, I'm not confused, because it's like we've come full circle in some ways based on the discussion of these things over the years and how we got to including this last section. And maybe is the remedy then that we drop this section, complaint submitted in bad faith, because we can add in this other simpler language, and then the process itself addresses it.
To answer your question, that kind of gets back to, yeah, the commission oversees this process. We should inherently have the ability to see how it's managed. Because let me take a step back. Complainants are availing themselves of the commission's process by filing a complaint. They're involving themselves in the process. The argument then goes back to, yes, it's inherently, they're involving themselves. We should be able to control it. Distinguish that with the direction from the Constitution and the process that the legislature set up doesn't come from the Constitution that created the commission. The Constitution says public officials, lobbyists, candidates for office. So when we rule make pursuant to that directive, the idea is it's over those people. So it gets back to when the legislature created the complaint process, that was something new. The Constitution says the commission can investigate alleged violations. It goes back to the commission's proposal during legislative session that we should align this process more with the constitutional language. Don't accept complaints, don't have a designated complainant, which would have eliminated this whole issue in the commission's perspective. That people, if they're not filing something, you're not availing yourself of this process. You're not involving yourself in this process. So we shouldn't have essentially a bad faith complaint, because the commission, as the entity investigating and following the constitutional directive, you're the one moving it forward, not the complainant. The commission is accepting information and moving those issues forward to figure out if there was an ethics violation. So it's all essentially kind of in-house, rather than having the complainant, continually involved up to the investigation. There was a lot there. If you have follow-up questions, happy to answer them, but it gets back to whether the commission inherently has the ability to oversee the process, and whether that's clear from what the legislature created remains to be seen. I think the argument is inherently the commission has to oversee this process. So yes, we should be able to have some say in what the complainant does or does not do throughout it, and how that impacts the respondent, but also the commission as the entity that has to work through it.
I think, Madam Chair and members, I think that we can all agree that the act of filing a complaint as a campaign weapon is a bad thing, or the idea of repeatedly filing complaints in order to make a candidate or a legislator or a public official's life miserable is a bad thing. And I think that we can probably also agree that that act itself is something that undermines the very purpose of the Ethics Commission. Perhaps the way to work through that is to simply have a independent rule that provides that it is the Ethics Commission's position that the act of filing a complaint to harass or in bad faith is in and of itself an ethical violation. Maybe that seems circuitous. Maybe it's awful doggone esoteric, but maybe the solution lies in considering what it is to be an ethical violation. I think it's, if a person files a complaint with the Ethics Commission, it certainly goes to reason that they invoke the jurisdiction, though we don't have that in black and white. I'm still not convinced that the commission has authority to impose a monetary penalty. I can't connect those dots. I would prefer that there's a legislative act that expressly states that, but I think that at a minimum, the commission enjoys the inherent authority, which probably should be expressed, should be in a rule, that can reserve its rights to, frankly, dispose of or impose sanctions as permitted by law for the filing of a complaint to harass or in bad faith. I think maybe I'm to the point where I'm just repeating myself, so I should shut up.
Well, Mark, I've got a question for you then. If we take a look at what sanctions can be imposed as permitted by law, and it is not a monetary imposition, what sanctions would you see other than that?
That's a good question. And right now, frankly, other than summary dismissal of a complaint or refusal to consider complaints if they continue to be filed in a vexatious manner, I feel like the statutes, Commissioner Goodman, don't give the commission a whole lot of authority, and I certainly don't see a monetary penalty as something that's authorized by the legislature. I don't see anything. I think that this is something that needs to be part of what we communicate to the legislature and the relevant committees and such, that we think is a hole in our authority. I like the language that states what, if any, sanction as authorized by law, because it commits that, well, we're not going to authorize sanctions that are not authorized by law. But I guess to go back to the original part of your question, I don't think that we have that authority right now, and that's what I struggle with. I think that that's something that we need legislative cover in order to do.
Well, Mark, oh, go ahead. I'm sorry.
No, go ahead, Ron.
You know, I agree with you to a certain extent, but I also agree with Logan in saying there's some inherent power that we have. What I'd like Logan to do is look at the rules of the Judicial Conduct Commission and see what sanctions, other than disbarment for a candidate or having a judge restricted for a certain period of time. I'd like to see if that commission has any ability to impose a monetary sanction or another commission, you know, because I know that this has come up before. You know, this is something we've struggled with in the past. And so maybe we just need a little bit more, and Logan, I hate to give you more work, but maybe just take a look at some of those things. And then as far as between now and the next, I'm going to turn my camera off because this sunlight's bothering bothering me. And if it's bothering me, it's probably bothering you too. And then if we have to live with that situation until we meet with the legislature, or until the legislature takes this up again, we may just have to live with that for the next several months. But Mark, I certainly see your point. So I guess I've said enough. Pam, I interrupted you.
No, you didn't. I think I interrupted you. I was going to say, I agree with Mark also that not everyone is on the same table, same page, seeing that we do have the authority. And I know it could be argued both ways, but also we're trying to, at this time, make some better relations with our partners in the legislature and the executive branch. And I'm not sure that the legislature would go for agreeing to pass something that said we had penalties, but I kind of feel like we have to give that a shot, rather than just going forward with doing it, because I feel like we're going to be attacked from someone by overstepping our authority. And I know that I know some of the reasons for both sides of why we do have authority and some of the reasons of why we don't have authority. And I believe there's going to be some arguments on both sides of that. And we don't need to start another big fight.
Excuse me.
Pam, I really appreciate your comment. And I want to make sure that we're clarifying the scope of the discussion that we're having here, is that we are talking about the limited instance of imposing a sanction in the complaint process that is pursuant to a statutory authority or directive from the legislature. That is distinct, and it is different than when we talk about a penalty that arises or may arise from the commission's constitutional authority to adopt a rule. So I want to make sure that that's distinct.
Thank you for
line.
that clarification. I appreciate that.
Yep, because whether the commission can issue or include a penalty in its rulemaking authority as rules relate to the 4 buckets, that's a separate question right now. This is in this complaint process, which has been laid out by the legislature, and the legislature has asked us to implement. Is there authority within that scope to include a sanction on a complainant? So I know that it's a bit of a legal distinction, but it's because the area or where the authority flows from is distinct. So, but Pam, I appreciate that, because I do think that we need to have that other discussion that you brought up about penalties in the rulemaking process. And we'll do that as Logan's preparing that memo.
Yeah.
So with that, I'm going to let Logan, I think he may have information already for you, Ron, regarding the Judicial Conduct Committee, or at least the Supreme Court. But maybe not. I might have just put him on the spot unnecessarily.
Kind of put me on the spot. To some extent, when we talk about attorney discipline, that's in the Constitution for the courts to create rules regarding attorney discipline. I'm not quite sure the distinction when it comes to the Judicial Conduct Commission. I think it's within the parameters of that. Not quite sure off the top of my head. But I think that's some of it, there is some case law on the inherent authority of the court to sanction, which is different from something that's prescribed pursuant to the Constitution or the Century Code. So there's levels to it. In a nutshell, it depends on where you're looking for the basis of the authority from, where you have to start the analysis. Now, when we look, as Rebecca said, when we look to public officials, lobbyists, candidates for office, we always go back to Article 14. Here, we don't have Article 14 to go back to because the complainant doesn't appear in Article 14. So we're going back to the Century Code to figure out, well, is it within the authority the legislature gave us over this process that they created for the commission to implement to ensure that complaints aren't filed in bad faith? So Article 14 is not really part of the equation for that analysis.
Well, after, in consideration of this, as far as I'm concerned, we do have the inherent authority from the legislature. But I recognize the need to have a little bit more clarification. I think we have the right to impose a monetary penalty, but I would defer to, I would hate to get into a court fight in the instance that if that came up. So what I'm going to suggest at this point is that the monetary penalties remain in place, but the $500 be changed to $100 for the first offense and $200 for any subsequent offense. That is still it's still a monetary penalty that is sufficient enough to get somebody's attention. Mark, would you have a comment on that? Or Jared, or Pam, or Cynthia? I should include everybody here.
I'm stuck at dollars at all. I appreciate the comments that Commissioner Goodman makes. I don't know that. I think the commission has the inherent authority to dismiss. I struggle with any other sanction without legislative cover. That's where I'm stuck. I can't get past that. I think that there should be an independent rule that provides that a filing of a complaint in bad faith is in and of itself an ethical violation, but in terms of a remedy or a consequence, I can't get past that, but I speak only on my own behalf.
Commissioner Goodman, this is Jared. I feel like if we were to update the new section to use the language we discussed earlier, the commission shall determine what penalty, if any, authorized under North Dakota law. I don't think we're giving up anything, and we're also avoiding a potential argument in the future until we determine, or to use Mark's term, until we get legislative cover for the specific type of sanctions we can use. So I'm more supportive of using the language that we discussed earlier.
You're saying add. I want to be very clear about what you're asking or requesting. So in subsection, what are they called? Articles, 115, 02, 01, 08. Subsection 6. the commission shall determine what penalty, if any, authorized by under North Dakota law will be imposed upon the respondent. And then mirror that language to include potentially a complainant.
I haven't fully thought this through,
Okay,
but what I am suggesting is rather than the language under the last article of this proposed process, we do include an article about a complaint submitted in bad faith, but rather than include the dollar amounts, we include language similar to the subpart 6 that you just described for how we may act if it's determined that a complaint is submitted in bad faith.
I would support that and include language that provides including but not limited to summary dismissal of the complaint.
And a follow-up.
in Mark, one question. So Mark, I want to make sure that we're getting the drafting correct.
Would you like me to formally make a motion to amend?
Not yet.
Okay.
I just want to make sure we all have the sections correct. So you were saying add in 115.02.01.03, submission of a complaint. Subsection 7. Subpart B, I don't know if it's called a subpart or part, excuse me, that the commission may summarily dismiss the complaint if the complainant, if the complaint, and then add as number 4, is brought in bad faith, or is some language is submitted in bad faith.
If the commission determines it is made in bad faith,
And then also include in 115.02.01.08 subpart or section 6, then add the language that we just talked about, that the commission shall determine what penalty, if any, authorized under North Dakota law will be imposed upon a complainant.
and I think maybe to tripartite, I would expressly state under 115-02-01-02, aka the jurisdiction section, that the commission shall, under sub 3, way at the bottom, the commission shall have jurisdiction over a complainant and respondent until the commission's final action on a complaint. I think that may clean it up. I would certainly be in favor and comfortable with amendments to that extent.
Okay, if I'm following this, and Mark, maybe this is for you, and I think I'm following it properly or correctly then. So I agree with where we're at, but then does that mean then we just delete that last section?
And when you refer to that last section, what are you referring to, Madam Chair?
115.02-01 sub 13, complaints submitted in bad faith. Can that just all be deleted?
I don't think it has to be. I don't think it has to be. I think that having express rule language over what can, I think I would delete sub 5 there and include the language that the executive director had just raised regarding may impose what penalty, if any, is authorized by North Dakota law. And I think the only other change I would make would maybe be sub 1 of bad faith, that if the executive director or commission, I think that the commission certainly has authority to make a determination, or a commissioner rather, strike that, because it has to be a decision of the entire commission anyway. I think each one of us has the right or authority to raise those issues.
Okay, okay.
I've got it all in my head, but it's not out on paper
Oh.
as of yet.
Yep. Commissioner Western, I think we got it all on paper, what you said.
Okay.
Then, I want to, if we were to adopt what was just proposed, then what this would be doing, and I'm thinking more 10,000 foot, not in the language. This would then shift the responsibility to the legislature that if they want to create a sanction, they are free to do that during the legislative session. And we have now then created a process that would allow for that. But because this is a process created by the legislature, it then allows them to choose whether they want to do that. And then our rule would fit the decision, or, whatever the legislature would choose to do with that. Am I
100%.
understanding?
100%. Yeah, absolutely. Yes.
Okay,
I
I've got
think-
one more. I'm sorry, Mark, go ahead.
All I was going to say is I think that we have a responsibility and an obligation to communicate to the legislature what we think. And, we're still barely toddlers or in elementary school in terms of the age of the commission and the age of the rulemaking. And we're fumbling through this because we're considering stuff that has not been considered in our state. And I think that there's a hole in terms of what and how a commission is permitted to impose a sanction. And I think that it's our responsibility to communicate with the legislature what we believe to be this hole, and to work with the legislature to ensure that the commission has the appropriate authority to do what it was created to do by the people of North Dakota. And I yield. I'm sorry, Commissioner Glidden.
Okay, this is Ron. And I know you recognize my voice, but you can't see my picture, and I apologize for that. But the sun is really coming in at an odd angle here. So anyway, we would have to, well, maybe we wouldn't have to, but section 4 of 13, the last sentence, we'd have to, or the last clause of that sentence, we'd have to take that out also. Or I suggest that in view of this discussion that we would take that out also.
Along those same lines, Commissioner Goodman, I was just reviewing part 3 there. The last clause of that part where it says the commission may impose to remain consistent. Would it be appropriate to take the same language and instead say this commission shall determine what penalty, if any, authorized under North Dakota law, etc., to close out part 3? To just use that same language. Maybe I'm muddying the waters, but I think we're saying
I don't see that 3 has to be changed, but go ahead, Jared, tell me why you feel, say it again. Why does 3 have to be changed?
Maybe I'm second guessing myself now, but purely to use consistent language, Ron, the same language that we would be saying will determine what penalty, if any. But I would be okay leaving 3 now that we're talking through it.
Logan, do you see any need to change 3?
No, not if you're gonna keep this section. I don't think you need to change it.
I'm fine with 3 as it is. I don't think that it implies that the commission has to, it must do something out beyond its skis. I think an appropriate sanction would be inherently lawful or legal, and it would be bound by the actual language in sub 5. I'm fine with 3 as it is.
Okay, are we all understanding kind of where we're at? With
I
how
have one
we're,
more.
I think so.
Cindy.
okay, go ahead, Logan.
Just, we're talking about changing the language for some summary dismissals to include a complaint filed in bad faith. Do we want to include that as a basis for a respondent to file a motion to dismiss as well? Those sections currently mirror each other. If we added to one and not both, then they won't. The second one appears on the bottom of page 4, top of page 5.
I think it makes sense to have those sections continue to mirror one another.
Yeah, I agree.
I
then
think
need-
it's appropriate. I would support it.
Do we
Yeah, fine
then,
with,
I support it.
fine with me.
in light of that support, would the commission then need to change what Cindy referred to as the last section, the bad faith section, to include that if the executive or a commissioner determines that a complainant, do we need to put anything in there about the motion?
No.
Okay,
In my mind, the way it would operate is that's one way it could be brought to the commission based on the executive director or commissioner. But if it's brought in the motion by the respondent, you jump to 2. If you determine that, order the complaint to show up.
okay, that, I agree with that.
And
Thank you.
for the benefit of the new commissioners, I don't think that we have ever imposed any kind of monetary penalty. Shoot.
Just a question on that, on number 1, if the exec director determines throughout this rule, didn't we change that to the commission?
Yes, Cindy. But here it would be because the executive director is the first one who's reviewing it. So then
Okay.
we would, the executive director, I try not to use I because it,
Yeah,
know.
yeah. Okay,
they likely will be somebody else. And then they would bring it to they will notify the commission. I do also like the inclusion of a commissioner here. That is,
okay.
I like that inclusion. That
Yeah.
if the executive director or a commissioner determines.
Yeah, okay, okay. So are we at a juncture where we can do a motion on how we've amended this rule? And Rebecca and Logan, you have enough, you've gotten all the language changes?
I have the ideas and some suggested language, so I should be able to put a draft together. Yes, Cindy.
So should we still do a motion?
I
I
don't think we
would.
have to.
I think so.
If you could give us the specific directive in line with your conversation, it doesn't need to be the formal language, just so that there's a record of the change before we move to a final adoption at whatever next meeting we take it up at.
Okay,
moved.
okay, go ahead, Mark, or whoever.
Well, I'm not sure. I move that the commission empower council and the executive director to provide amend. I don't know how to make this motion. I think I'm going to end up sounding
I'll
really
do it.
stupid. Please,
Mhm.
I
I'll do
yield and withdraw.
Uh, I, I move that the legal counsel and the legal counsel for the commission and the executive director amend 115-02-01 of the commission's rules pursuant to discussion the commission had during its special meeting on February 21st,
January.
January 21st, January 22nd, 2026.
Okay, we have a motion,
Second.
second by Mark. Any further questions or discussion?
The one question from me, this is Jared, is
Yes.
there a deadline for us to adopt this? Is that at the end of this month?
It's February 19th.
February 19th. Okay, thank you. Thank you.
So if the commission amends today, we can do final adoption next week and be okay on the timeline. Anything past the next meeting, I'm gonna ask Cindy to call you guys back for special meetings.
Point of information or point of something. Is there any obligation now that there will be draft amendment any further for public comment or submission to any other entity to satisfy any rulemaking requirement?
No, not at
Okay.
this stage.
All right. Hearing no further questions or comments, Addie, please call the roll on the motion.
Commissioner Hubrights,
Aye.
Commissioner Western,
Aye.
Commissioner Sharp,
Aye.
Vice Chair Goodman,
Aye.
and Chair Lindquist.
Aye. Great discussion. And I'm going to take the chair's privilege of calling a 10-minute recess. Take a little break and regroup here, and we'll reconvene. I have 11:50. We will reconvene at 11:10. Commissioner Goodman has let me know he is on, though he doesn't have his camera turned on, and we, I think, are all back. So we will reconvene the special meeting of the North Dakota Ethics Commission. And the next item on the agenda is the discussion of the public priority survey. Rebecca.
Cindy, we're gonna get it up so that commissioners can see. So to provide some background on what you are seeing on the screen, after we set our strategic planning meeting for the day after our regular scheduled February meeting, which will end up rolling all into a one meeting that lasts 2 days. I was doing planning and prompts for the commission to work through what the changes that we need to make or should make to our strategic plan moving forward to make it less aspirational, more measurable. And one of the thoughts that we had in the office is, man, wouldn't it be nice if we could get some input as the commission is moving forward with its strategic plan about what the people of North Dakota want. And the reason is because the commission was put in by the voters. And so it would be really great to have that input. And so what we did is we worked with NDIT to create what is a public priorities survey. It gives us information about what topics the public would like to see the commission address. And when we say address, that the commission is going to address it, perhaps they will support legislation, draft a rule if it's within the authority granted to the commission in the Constitution, or it will help with other agencies improve processes. So this doesn't necessarily make a direct link between a commission rule and a topic that's introduced. It's really what is a priority related to ethical and transparency issues to the people of North Dakota. So you will notice that the topics in question, I believe it's question 7, are they're broad. They cover a lot of different things. Now, Chair Lindquist and I went through these questions or these topics. I will first note that they are called issues. Chair Lindquist had the suggestion that has a negative connotation. And so we will request NDIT to change that to topics. I did not have a chance to do that yesterday. I will do that today. And then we also will be combining, Addie, if you can scroll down just a little bit, combining the last 2 that relate to, right, stop. Oh, too far. Yep, too far. There we go. The last 2 topics in question 7 that say campaign ethics and reporting, and then the next one says campaign finance, disclosure, and compliance. We feel that those 2 probably overlap and can be combined into one. So I want to get feedback, or Chair Lindquist wanted to get feedback from the commission. Thanks to NDIT, they got this up. You'll see that it looks like it's on our website. It is not yet on our website. This is a link that we can edit. We've tested it. It does work. Other information that the commission needs to know is we can make this live as early as likely Friday, maybe even tomorrow. Oh, tomorrow is Friday. Sorry, tomorrow. Excuse me. We will have a QR code that we will post on our social media, on our website, and that we will then send out to individuals with a link. So you'll get a QR code and a link, and that individuals can go to fill this out. Now, I will recognize that this obviously has limitations. You will notice the very first question asks if you are a North Dakota resident. People could easily lie about that. I mean, that is a possibility. You run into that with any kind of online survey, that there is not honesty in the answers. So we do need to recognize the limitations of this, but also this could potentially give the commission some good information. It is very little cost, and that's why I'm bringing it to the commission. I think that it could potentially work nicely if the commission wants to use it. This will be available, accessible through our website, and we'll get information out as quickly as we can, beginning as early as tomorrow. And we can leave it up until approximately February 13th, which would give us several days to compile the information and then be able to present that during the strategic planning portion of the meeting on February 19th.
I
That is all.
will jump. I think it's a great idea. I think the more information we can get from the public, the better. If we can get some, I think that'd be great. I like it.
Does anybody have any changes to questions or comments or concerns about doing this, et cetera?
So we'll put this on our website. And just thinking of other avenues of distribution, or if that's
Yep, so it'll go, so to clarify, it'll go on our website. As soon as it goes live on our website, we will send out a news release. And that will go out to all, anybody who falls within our jurisdiction. Agency contacts, so even if they don't fall within our jurisdiction, but it'll go out to state agency contacts. It will go out to our media contacts. It will also go out to registered lobbyists. And it will go out to anybody who subscribes to the commission's news and alerts. The other avenue that we looked at doing is reaching out to civic organizations that we can ask them to share the information with their membership. And then the last one that Addie and Logan had was to publish the QR code in all of the county newspapers, which we can do the first week in February. And that has a fee of approximately between $700 and $1,200 if we do it that way. So because that could potentially be over $1,000, I would want authorization for the commission to do that specific thing.
Well, I agree with Pam. I think it's a great idea. I'm supportive of the effort as proposed.
Do you need a motion to authorize the cost if it reaches $1,000?
Preferably, Pam, I have just a general motion in the memo to approve the distribution as outlined, but you could be more specific too.
I'll make a motion to authorize the expense of putting the QR codes in the papers and to distribute the questionnaire.
Okay, we have a motion
Second.
and a second. Further discussion or questions? Yeah, I'm going to just make the comment that I believe this is the first and only time we've done this. And we've had a strategic plan since our inception to the best of our ability in that. But I truly believe we're kind of at a very different juncture than we've ever been for the commission and the work of the commission. And so I too agree, and I like the aspect of asking the public to provide some input for us as we prepare a new plan for the commission's work, and also in preparation for the 27 legislative session. So I think it's going to be valuable. Hopefully we'll get a lot of responses in that. And I think the more we can publicize it, including ourselves, to make sure our friends and colleagues and whoever knows, yeah, hey, we've got a survey out there, please fill it out for us. And then please do take time to look at it. Rebecca mentioned, as I looked at it in preview, again, the word issue for me was concerning. And so that the word issue is going to be changed to topics. Just to change I guess the content or the how it sounds in that, and not to, I guess, for me, not to influence people thinking that, oh, we think these are issues or problems or trouble or whatever, just a different context in that. But do look at it. And if you have any other suggestions, would need to get that to Rebecca today, or maybe by noon tomorrow at the latest, so she can then direct NDIT to make those changes for us and to get it live.
Madam Chair,
Yes.
this is Jared. I see in the memo that it stated the submissions are anonymous.
Yeah.
Do we want to put that statement at like the top of the survey?
So Addie, can you go back to, so it won't be on the top of the survey, it will be on the landing page for the survey.
Okay, that's fine.
So there's a landing page, and I don't know if Addie can pull it up. We don't have all the language on there yet, but there will be a landing page that you're brought to that says, this is the purpose of the survey. And it will have it on there that it is anonymous.
Okay, great point. Anything else?
It's okay.
Okay. Yeah, it's okay. We also have a bot protection on here, just a FYI, because we have been botted before with our online forms. So yes, you will see this is it. We're not done with it yet, but this is what it will look like. And then you will click to take the survey. There will also be a rotator, meaning on the Ethics Commission page, when you get on there, you'll be able to click on the rotator and it will take you to this page as well. And there will be a specific tab on the Ethics Commission's website during the survey timeframe that will allow people to submit it that way. So we're trying to make it as accessible as we can.
All right,
if-
hearing, go ahead, Rebecca, sorry.
I was going to say, if anybody has any other distribution methods or modes that we could utilize that we haven't thought of, I would love to hear them. Perhaps you have a network that you can tap into to get information on that. We'll likely send this out in the daily email that attorneys in the state get, but any other suggestions, we would more than welcome them.
All right, hearing no more questions or comments, Addie, call the roll, please, for the motion.
Commissioner Hubright,
Aye.
Commissioner Western,
Aye.
Commissioner Sharp,
Aye.
Vice Chair Goodman,
Aye.
and Chair Lindquist.
Aye. Motion carries. Good job. All right. Our last item on the agenda for the special meeting today is the annual statements of interest. And if y'all looked at that material that she sent us, I'm just like, oh my gosh, really? And I clear for myself personally, it's like, okay, this is just that form thingy that we used to fill out on paper and now it's being done electronically. So it's like a new process, but it's electronic. And Rebecca, are you or Addie going to walk us through this or?
So we were going to walk through the whole thing. The quick start guide that we sent you all, that we received from now it is like 41 pages. I think the quick start guide is 41 pages, right? Really the kicker is you make a login, you go in and enter the information. And if you have questions when you do this, reach out to Logan, Addie, or I, and we will walk you through it. If you also want a copy of your current statement of interest form so that you can copy and paste, we do maintain those internally, so we can get you that copy. And I apologize, the commissioners, Pam, Mark, and Jared, who just came on, you guys are kind of getting double smacked based on timing. But it is just the way it is. This is a piece of legislation that the commission was fully behind, testified in favor of multiple times, and worked with the Secretary of State's office for months to get to the legislature. So we want to be the example of compliance.
I appreciate that you're willing to help us if we need help, because I know I'll be calling one of you, because I tried to get in there and it was like, oh, because I previously had an account on their website and it's, yeah, so I might need help. Thank you.
Yep, we can walk you through it. And we might need to call up the Secretary of State's office and have them help, but we'll get there.
Okay, thank you.
And this has the deadline of January 31st, right?
And there are late fees associated with not filing it. So if it is not filed, you will personally incur late fees.
I've got a stupid question. Where is it? Where's the form?
Ron, you have to create a login on the Secretary of State's website. And then
Okay.
you fill it out electronically. There is
All right.
no longer any paper form.
Okay.
But
So
she
I go
sent
to
us
the-
She sent us an email with the link.
Okay. I can't see the email. Where's the email?
I think it's dated January 14th.
Yeah.
January 14th.
I'm happy to forward it to you if you can't find it.
Well, I should be able to find it. You guys don't know this, but I have been a problem child as far as some of the technological stuff is concerned. So they'll forward it to me if I can't find it.
No, I'm gonna say, nah, you're not the only one as the problem child. Relative to technology, it's like, oh, whoops, wait a minute. But I think it's pretty self-explanatory. It's just that for me, it's the tech side of it, getting in there and making sure I set my account up and then just filling it out like I used to fill it out on the paper form. So
Yeah.
But just be mindful of the deadline. Okay, anything else?
Just a note that we have it set on our calendars with reminders like every 4 days. So you may start getting email and text reminders from us.
Good.
We're not trying to be bothersome. We're just trying to be compliant.
You said that before, that you're not bothersome.
It's a fact, Ron.
I'm just kidding. I found it finally.
All right. That takes care of our items on the agenda for the special meeting. Hopefully it'll all stay warm. Pam, hey, it's warmed up from 17 below to 15 below.
Oh,
Grand Forks.
congratulations. We'll see if you can notice that when you get outside.
Right, right.
Yeah, a fun thing to do, if you want to do it, is to take a cup of really hot water and throw it up in the air. And
Outside, yes.
outside, yeah, don't do it inside.
And then add some food coloring.
Yeah, there you go.
Create your own icicles, yes. And I'll just remind everyone, we have our regular meeting next Wednesday, January 28th, beginning at 9 a.m.
That's the one I thought I missed today, but I'll be there.
All right,
thank-
thank you all. Good meeting, good discussion. Thank you, staff. Everybody, please take care.
Thanks, boss.
Bye-bye.
Bye.
We are adjourned.